With regard to retirement in particular, some of the most destructive decisions by the Supreme Court have been under the ERISA law from 1974, and the first, I think I could narrow this to a few decisions. The court decided on a 5-4 basis way back in 1993 that when the protections of the ERISA law for people's job benefits, including pension benefits, are violated, including the wrongful denial of benefits or reduction of benefits, that essentially you can't get money damages in court, and the result has been that in many cases there's really no remedy at all. There's no way to get into court unless you can get into court quickly in such a way that you can get an injunction to stop the employer or the benefits administrator from doing what they're doing that's in violation of the law. Unless you can manage to do that, which in many cases is impossible by the time you get to court, that there's really no remedy under the federal law, something that Congress could never have anticipated. And in the years following, the court also decided in a series of cases leading up to a 2004 decision called Aetna Health Inc. versus Davila, that remedies that had long existed under state law, under the common law of fraud and breach of contract, etc., that those sorts of remedies were also were essentially invalidated by the ERISA law. So the Supreme Court held over the last 20 years in a series of decisions or the last 15 years, that this law that Congress enacted 34 years ago, in order to protect primarily in order to protect people's pensions, that the protections it creates, that there is, in very many cases, no remedy for the denial of pension benefits in federal court, but that the federal law also eliminates any sort of remedies in state court. Now, a number of judges and scholars have noted that these decisions, in addition to being contrary to what Congress expected and when they wrote the law, create a perverse incentive for the administrators of these pension plans to do things like close plants or structure their corporate purchase agreements or sales of the various subsidiaries and things like that in such a way as to frustrate employee pension rights. And there have been a number of cases like that. There was a case that the Supreme Court refused to review just recently in which a woman was denied her husband's life insurance policy because while her husband was out on medical leave fighting cancer, the employer changed its life insurance carrier. The new life insurance carrier had a policy that they didn't tell anybody about, that federal law required them to tell employees about, that people out of medical leave had to come in for one full day of work at least, after the time when the new policy became effective in order to get for their benefits to vest. Well, the employee, the husband, was never notified of this, and in fact he repeatedly inquired for assurances that his coverage was going to be honored and was assured that it was going to be honored. Well, ultimately he loses the battle with cancer, and his wife is ultimately denied the benefits because of this policy that they essentially hid. And even though the company clearly broke the law, this woman was kicked out of court and said, well, they refunded your premiums, but you can't benefit from the life insurance policy, and you can't go to court and get the life insurance benefits that you had expected all along.
What impact would a ruling like this have on, say, state insurance laws, where the jurisdiction of, say, a health insurance policy was under a state Department of Insurance?
Well, the federal law does say that state laws regulating insurance, the insurance business, are still valid and are not affected. But that nevertheless hasn't that's part of a savings clause in the law, but the impact of that is very limited because while the sort of technical and administrative aspects of regulating the insurance industry are not affected by these court decisions, any kind of claim to take the employer or the benefit plan administrator into court for the wrongful denial of medical coverage or the wrongful denial of pension benefits is pretty much precluded by these court decisions, even though technically there are state laws that cover it. There are other aspects of state insurance regulation that are not affected, but the basic
contract law.
Remedies for people who have been denied benefits, whether it's health insurance, life insurance, or pension benefits, are not there anymore.
So really it comes down to whether you want to complain on a basis of contract law or a basis of violation of insurance law.
Well, violation generally in these kinds of cases. I mean, I'm no expert on the substantive law underlying these sorts of claims, but generally, you can't. State insurance law doesn't usually govern these cases. It usually would be state contract law or the federal ERISA law itself.
Which is usually in cases of self-insured insurance plans, which many people don't realize until they get into the contract of what their employer actually signed.
Yeah, so that's the nuance that I've missed here, is that there is a difference between self-insured and externally administrated plans under the ERISA law, but in a great many cases, and so yeah, in depending upon whether the plans are self-insured or externally managed, actually makes a difference in whether you can sue under these state insurance laws. But an increasing number of employers are going the self-insured route. But that, as I understand it, creates something of a shelter from this denial of access to court to enforce the law.
What is it going to take to change all of this?
What it's going to take to change all of this is, unless the Supreme Court realizes the error of its ways, which in denying this life insurance case, this term, it pretty much ruled out doing, I think, it's going to take action by Congress. Now, Congress was very close to fixing this problem in 2000 and 2001. This was part of the fixing this problem was part of the Patients' Bill of Rights legislation that was on the table back then and was passed in differing forms by the House and Senate, but was never reconciled and enacted. And that would have been the various proposals then would have enabled people to either go to federal or to state court to sue, the plan administrators when they wrongfully denied benefits, the employer when they close a plant in order to avoid people's pensions vesting, or the HMO when they wrongfully deny needed medical care. And that's kind of been off the political radar ever since for various reasons. But one hopes that with the renewed attention in Congress that this could be something that's part of the health care policy discussion in the next Congress.
Do you think that now that the Democrats control the House and the Senate, that is a possibility for reconciliation, or perhaps something be done before the election this year?
I don't think there's the momentum to fix ERISA right now. I think that the only things that are getting through Congress right now are issues that are incredibly high profile, that have but are either connected to sort of emerging, the top headlines about, economic issues, mortgages, and oil prices, and et cetera, and things related to war, and or things that have had built momentum over a long time. The ERISA remedies issue, in other words, getting into court to enforce your right to pension benefits, has just not been on the legislative radar for the last several years. And it seems to me, although I'm not, the legislative expert around here, that it's not likely to be fixed this year. We'll have to see. We'll have to see next year.
All right. That will do it. Was there something else you wanted to mention?
Yeah, I think that, you asked me about pension benefits in particular, and I think there was another issue that was alluded to by Chairman Leahy in this hearing that was not addressed by the witnesses in depth, but was addressed by our organization's statement, and was one that also affects pensions, and that is the court's decision earlier this year on securities fraud that limited the ability to go after parties that commit securities fraud, and some of the biggest losers in that are small investors, including individual seniors, but also public and private pension funds. Public pension funds from a great many states and universities and et cetera. The public filed an amicus briefs in that case because when securities fraud happens on the level of Enron, pension plans that are heavily invested in those companies where the fraud is going on can really be hurt very badly, and people's retirements can be jeopardized. And what the Supreme Court held was that in a situation like Enron, where you have a company that's where there's fraud going on, where the company ultimately is financially decimated, is bankrupt because its fraud is revealed, but there were companies that were doing business with Enron or XYZ Corporation that constructed with them the scheme to defraud the investors, that you can't go after those still solvent parties that constructed and benefited from the fraud scheme, even though they may be the only bad actors that actually are still solvent and can provide some compensation to investors like public pension funds. And so while the issue of securities fraud is specifically thought of as being a kind of an arcane business law issue, the court's decision, basically cutting off compensation for securities fraud in cases like Enron could have a big impact, detrimental impact on pension funds across the country. And this, along with the ERISA decisions, along with the sorts of decisions about arbitration and punitive damages, and the medical devices issue addressed by the court's hearing in June, are all issues, are all ultimately about twisting federal legislation, the work that Congress has done to protect people, into being a shield for businesses that prevent seniors and other workers and consumers who have been denied these basic legal protections, shield them from people being able to go into court and get some kind of compensation. Congress has not paid a whole lot of attention to these kinds of decisions in the past, even though they've had a real bad effect on people. They're kind of under the radar. It's not as though a federal law is being overturned outright, but the protections that they provide to people are being eroded. So yeah, it's not something that is easy either for media or for legislators to notice and grasp all the time.